keep your papers and pencils out because, as important as fair housing is, we have them here almost every year. But what's really important is they're also going to cover the new Toledo rental laws. They're advocates and they track the new laws for Toledo rentals. Fair housing also will be, like I said, enforcing these laws, but they also have something else that I've used that most of you don't even know exists, and it's called mediation. And it's a nice place to go when you have a difficult tenant or a difficult situation to take care of. So let me introduce to you Sarah Jenkins.
Hi, everyone. Nice to see everybody again. Thanks so much for having us back. So I'm Sarah Jenkins. I'm the Director of Public Policy and Community Engagement at the Fair Housing Center. Normally when we come here, and you may have seen our presentations before, normally we're kind of doing an overview of fair housing laws. But today we wanted to do something a little different. There are quite a few local laws in the city of Toledo that pertain to rental properties. Some of those are new. There have been some new ordinances passed in the last couple of years. Also, there are some ordinances that have been around for a while, but we often get a lot of calls and questions about those. So we just thought it would be a good idea at the start of the new year to kind of get everybody up to speed on some of those local ordinances that affect rental properties. So I'm going to turn it over to and introduce George Thomas, who's the Vice President and General Counsel at the Fair Housing Center, and he's going to walk you through the ordinances. And as always, we certainly welcome questions at the end of the presentation because we want this to be helpful and informative for you.
Awesome. Thanks, Sarah. So again, my name is George Thomas. I'm the Vice President and General Counsel for the Fair Housing Center. And I've been with the organization for about 2 years. And like Sarah said, we're focused on fair housing enforcement, but separate from that, okay, like divide a line in your mind, we have a different landlord-tenant mediation program that's like kept separate from that. And part of the purpose of that program is to help, like Anna said, resolve conflicts between landlords and tenants to try to maybe prevent evictions. It costs money for the investors, and obviously the tenants don't like that either. But in part of that program, what it does too is that sometimes it doesn't provide legal advice. So I'll get to this in a second, but what it can do sometimes is provide some education and information to both sides about local policies, which can sometimes help with resolving conflicts. Certainly that's not the only thing that it does, but that's part of what it does. And so that's part of the vein of why we're here today. What we're presenting is information about those local laws, like Sarah and Anna both said. So I'll try to provide, in the brief amount of time that we have, relatively brief amount of time that we have, an overview of those laws. One of the handouts that you had from Anna lists a good number of the laws that I'm going to try to walk through. And like Anna already said, some of these are new, so I'm guessing you may have questions. I've built in some throughout the presentation a couple of spaces where I'm guessing that someone might want to raise their hand and ask some questions. So we'll start out with a discussion about the local anti-discrimination laws, and specifically the new rules related to source of income discrimination. And when I get done with that part, there's going to be a moment for you guys to be able to ask questions, and I'll try to provide some answers based on that particular policy. Then second, this has already been mentioned or discussed by Anna and is on one of the handouts as well, but I'll be focusing for a little while on the local rules related to water access for tenants and billing tenants for water, and then shutting off from water where there's a property that has a rental, someone who's actually living there at the time. And finally, third part, I'm just going to do kind of a quicker overview of some of the other more recent laws that would include things like the lead ordinance and a couple of other provisions in the local law that aren't maybe not necessarily new, but they're provisions that you might not be aware of. We just, in our experience of working in the housing realm, we come across a lot of folks who don't necessarily know about some of these other local laws that I'll be discussing in the third part of the presentation. So just a really quick disclaimer. So I am an attorney, but I'm not your attorney. This information is not intended to be legal advice. It's not forming an attorney-client relationship, with RIA. We're just here to provide general information that we hope is helpful to you all and give you guys a chance to ask questions and have a little bit of discussion about some of the local policies specifically in our area. So again, these are all of the rules that we'll be talking about apply really only inside the City of Toledo's municipal boundaries. We're not talking about rules that apply, outside that, wherever it's Sylvania, Amami, et cetera. It's just, these are laws that were adopted by the City of Toledo's City Council at some point. The legislature for our municipality as a local government, adopted these, passed them. So the first one we'll talk about is the newer provision about source of income discrimination that's provided in the Toledo Municipal Code at Chapter 554. So I know that's like a lot of text on the screen there, but don't worry, let me give you some context for this. So first of all, the City of Toledo has for many, many, many years already had a local anti-discrimination rule that applied to both the real estate transactions and employment issues. So that was something that was on the books for many years and had been kind of updated maybe a little here and there in more recent years. So a few years ago, for example, Toledo City Council added sexual orientation as an additional protected class for those other protected classes that were discussed in the local anti-discrimination rule. But basically what the rule had always done was it prohibited, as a matter of our local law in the City of Toledo, discrimination in real estate. Like, let's say you're renting a home or selling a home, and you decided not to sell it to someone based on one of those protected classes, whether it's race, religion, ethnicity, et cetera, or not, in more recent years, like I said, they added sexual orientation. Oh, and the same thing is true in the employment context. Like, say you decide to fire someone or hire someone that was in a way considering their protected class. So what we have, City of Toledo did most recently, though, in changing Chapter 554, was added the source of income as a protection. So what that means is that if a tenant is applying for a rental unit, and part of your consideration of that application is their income level, certainly that could be appropriate. Let's say a lot of landlords look for 3 times the income and 3 times the rent and income. That's fine. But if you start to delve into where that person is obtaining their income, let's say, for example, if they're getting some of their income from Social Security disability, or one of the primary purposes of the law was, what if that person is getting income to pay rent from the Housing Choice Voucher Program, their Section 8 Housing Choice Voucher Program? You can't deny that person simply because the voucher would be their form of income to pay for their rent. Now, I should also point out as a point of context that this type of protection, this quote-unquote source of income protection in local laws, is growing and growing all across the country. So, for example, Columbus, Ohio has adopted a source of income discrimination law. Some other states all across the country, like statewide, have adopted an anti-discrimination law that says you can't discriminate based on that person's source of income. But the bottom line, though, is that if this is a misdemeanor offense, there are some penalties to, let's say, for in your position, if you're a landlord who's considering applications and you say, let's say you just advertise and say, no Section 8, like I will never accept Section 8. That is now prohibited as a matter of local law. Again, this is only inside the City of Toledo. Outside of Toledo, this particular provision doesn't apply. So I just wanted to go through, focus on, spend a little bit of time to make sure folks are understanding what this means with a few frequently asked questions about source of income discrimination and as the local law. And at the end of this part, we'll open it up for some questions if there are any. So first of all, like as I already explained, source of income is a protected class in the city of Toledo. This means housing providers cannot deny housing to someone or treat them unfairly because they have a non-traditional or different form of income, such as a housing choice voucher or or Social Security disability, just as an example. What types of income are covered by sources of income protection? Well, all legal, reliable sources of income, including Social Security, disability, and military benefits, and housing choice vouchers. Indeed, when I had the definitions on the screen, you saw like all those types of income were listed or included in some of the terms provided there. How does this impact tenants? Well, tenants with non-traditional income should have the same chance as any other tenant to apply for housing, and tenants should not be really treated differently just because they have a housing choice voucher or if they are using like military benefits or other types of benefit assistance programs in order to pay their rent. You're really just going to treat them the same way as any other applicant. You can look at the total amount of income they have. Well, let's say if part of it's from Social Security, part of it's from a housing choice voucher, but total, if it meets your normal requirements that you assess for all tenants, then you should generally be accepting that person and not discriminating based on what the source of income was. Will housing providers have to change their screening processes? Well, as I just said previously, like typically, no, not really. A lot of housing providers don't really necessarily particularly consider whether the person has a voucher or not as part of the screening process. If you were considering the source of income as part of your screening process, then yes, you may need to change that to make sure that you're not discriminating based on source of income. But otherwise, you can still look at like I emphasized, the total amount of income. You can look at prior rental history, all that kind of thing. None of that is prohibited by the law. It's just really focused on the actual source of income. Does the source of income protection impact the cost of housing? So no, it doesn't. It doesn't. So one kind of common misunderstanding is, well, does this mean that I have to like lower the amount of rent that I charge, or in some instance like raise it? No, you're still setting your rents at a certain amount, and the voucher, for example, if the person is applying has a voucher, is either going to cover that amount or they're not. Hopefully, if the voucher recipient gets instructions from the public housing authority about how much their voucher is actually going to cover. And they'll be knowing when they're applying if the voucher would actually even cover that amount. But in any case, the law doesn't really require you to change anything about the total amount of rent that you're going to be charging or security deposit, things like that. It's just, again, focused on the actual source of the income that the person is offering. Can housing providers require proof of income? Yes, again, certainly you can do that. Doesn't change other aspects of the screening process. You can look to confirm, like if the person is saying, well, I'm going to pay with Social Security disability, you can still say, well, I'm going to need proof of what that amount is, or if it's military benefits. And of course, with the voucher as well, you can ask for some confirmation that they actually have that. That would be part of the screening process. Can housing providers set criteria related to the amount of income a tenant receives? Again, yes, providers may require tenants to meet a minimum income level, for example, requiring that tenants must have monthly income equal to 3 times the monthly rent. The protection extends to the source of income, not the amount of the income, as I've already said. But one thing to keep in mind with this, one kind of common problem that comes up is people will say, well, what if it's from multiple different sources of income? Well, you shouldn't be distinguishing that. You should just be really looking at like the total amount of the income that the person is presenting, as long as it meets whatever threshold you have. If it's 3 times, for example, then that should be sufficient. Does this change how a housing provider advertises their available properties? Well, again, for most people, no, not really. You're just putting an ad out that says, there's a rental property available, this is the characteristics of it, et cetera. But if you're one of those folks who is affirmatively putting out there no Section 8 or this is far less common, but, I won't accept payments, income from someone who has Social Security or military benefits. But we would, in the past, we would see, from the Fair Housing Center, would see, and folks calling us would report, they would see ads out there just saying directly, like, no Section 8. So obviously that kind of advertising activity would be prohibited by the local law. What does a housing provider need to do in order to accept the Housing Choice Voucher? Well, that's a great, I want to be clear that we can speak to this law as an anti-discrimination law, but we're not the public housing authority. But essentially, you just cooperate with what the voucher holder is presenting and cooperate with the public housing authority. In sort of broad terms, the housing authority just needs to be able to perform an inspection of the property, take a look at it, make sure it meets a very low-level HQS standards, housing quality standards, which are typically fairly easy to pass. The form for the housing quality standards inspection, if you ever look at it, it's just some series of relatively basic questions about making sure that the property is fit for occupancy. And then otherwise, the local, our PHA has a payment system that's based on direct deposit. So you just get set up into their system. And actually, if you've ever had that experience with voucher, the payment system, it is obviously fairly reliable once you get into the system and you get your payments in regularly each month. What is the benefit of source of income protection? Well, as I was mentioning earlier, like a lot of other local jurisdictions all across the country, the states, cities, have started to adopt more and more of these source of income protection laws. Part of the goal here is to allow people a better opportunity to access the housing that they want for their families. So even if they have a housing choice voucher, that should allow them to be able to access different neighborhoods anywhere that they would normally be able to afford with that amount of money to pay rent. That's the basic idea of it. In the Toledo area in particular, the Fair Housing Center has seen that housing choice voucher families tend to be particularly clustered in only certain central city neighborhoods. We just know that from data that we've obtained from the Public Housing Authority that shows where housing choice voucher families are living. And we know that it's been tough in our area for the voucher families to access other neighborhoods outside of those areas simply because of discrimination based on that source of income. So one of the goals of that local law, just like it is in other cities and other jurisdictions, is to open up neighborhoods, open up fair housing choice, et cetera, for those families. So I have a quick quiz. You don't necessarily have to answer, but maybe think of the answer in your mind, so we try to keep things interesting by asking some questions, but you can answer out loud if you'd like to. Otherwise, you just hear me droning on about the law. So a tenant received a one-time cash gift from their grandmother, but it is not a steady source of income. The tenant asked the landlord to count the occasional gift as income. The landlord refuses. Is that source of income discrimination, the landlord refusing there? That's right, I heard you guys, I think most people saying no, that's right. No, because that's not a consistent source of income. So no, that's not really discrimination based on source of income. So a tenant offers a one-time payment that covers more than 5 months of rent and promises that they will have income from a job before the end of the 5-month period. The landlord refuses to accept this income and denies the application. Is that source of income discrimination? Again, no. It's like that's not a steady, source of income. Just because they have that one-time payment, that's not, a reliable source of income. But a landlord advertises no Section 8. Yes, that is source of income discrimination. An applicant receives Social Security disability. The landlord doesn't like Social Security disability, but it's because they're just concerned they will be unable to garnish wages if they don't pay. The landlord denies the application. Yes, that's source of income discrimination, that's right. A landlord requires 3 times the rent and income from a tenant. An applicant has 3 times the rent, but it's from multiple different sources. Maybe they have a part-time job, let's say, and then they also have their Section 8 voucher in addition to that. If you took away the part-time job, the voucher wouldn't cover enough, and the part-time job by itself also would not be quite enough. Is the landlord decides to just deny the application, is that source of income discrimination? Yes. Wow, you guys are aces. You already know all this stuff. Why am I even here? This is great. So like I said, I built in a few pauses here. I think you may have written down some questions in advance, and that's fine too. But are there any particular questions about source of income discrimination that you guys have that are brewing to the top right now? Yep. Sorry, I think they were saying to wait for the mic.
for the
I
mic.
apologize. I'm new
Got
here,
any-
by the way, so I don't know all the rules.
Any questions?
The question I have is I didn't hear well when you got to the part about being able to verify the income. Is there a certain procedure we have to go through in order to do that, or we can't do it, or I missed that part?
No, you're allowed to verify the income. Yep. And there's, and whatever your normal system is for verifying income, it's probably fine. Like, so it may be different depending on the source. So if you say that the person says, I have a voucher, you could ask for documentation that shows that they actually have the voucher, let's say, hypothetically. But you have a lot of discretion about how to verify the source of income. That's up to you. Or if the person gets Social Security, you could say, well, can I have show me that you have the letter from Social Security about what, the amount you have, for example. That could be one way of verifying it.
We also have one here, Section 8 what Section 8 covers would be too low, and they want us to add that they will add money themselves on the QT, don't tell Section 8.
Yeah, don't do that. Yeah, don't do that.
With that, we get that
That's
a lot.
bad,
We
right?
get that a lot. The
Yeah.
other one is a friend wants to live there too, but they don't want to put them on the lease because it's not allowed by whatever the voucher is.
Yeah, again, you can't do that. Yeah. Yep.
What if the rental is not Section 8 compliant? Doesn't
What-
pass the inspection?
Yeah, so again, the housing quality standards inspection, if you talk to the Public Housing Authority about that, or maybe try to get a copy of it, the form that they use and the inspection uses, again, I would just emphasize it is pretty basic. It literally asks, if you ever look at it, it asks questions like, is there a bathroom? I mean, I'm serious, or is there a bedroom, or there are walls, those kind of questions. Most of the time it's really easy to pass out. If there are some kind of safety issues, if there's not a smoke alarm or something, something like that, I would say, I would encourage landlords to consider, if something is marked off in the HQS, it's probably something you want to fix anyway for a number of different reasons, whether it's liability or, you just want to make sure you have a habitable unit. I would just encourage them to make sure that they are fixing those. One thing I should mention too is not necessarily in this jurisdiction, but because there's been so many of these other laws all across the country, there have been some cases where, let's say, someone is intentionally trying to mess up the HQS inspection so that they don't ultimately have to accept the voucher because they just don't, they want to discriminate based on source of income. Then obviously, if there's some kind of evidence of that, that could end up appearing to be source of income discrimination.
We sort of have a backup for that. What if the rental passes Section 8 for the beginning inspection, but then after the tenant's been in it, it no longer passes?
Okay, so if you're not familiar with how those housing choice voucher HQS inspections occur, yeah, there's the one at the outset, but then there could be one later. Maybe it's because the tenant calls the Public Housing Authority and says there's an issue, or there's just another inspection later on routinely. And if an issue is identified, the inspection also indicates who's responsible for it. So based on what the independent inspector looked at, they identify if this was something that appears to be caused by the tenant, or if it's something that the landlord should be responsible for repairing as part of their normal duties of maintenance at the property. So I would just point out that in that instance, you could let's say if the tenant caused the issue, then you have recourse, the normal recourse that you would have to be able to say, well, we think that you breached the lease here. And at some point, if in any case, if the issue is not resolved, then eventually the rent would go into abatement, and then the person would ultimately need to move as part of that process anyway. Hope that answers that question.
They'll quit the payment, but you have to do the eviction.
Yes, just like any other, any other
Okay.
tenant. Yeah, exactly. You would have to do that. Yep.
What if you aren't interested in dealing with Section 8 process, lengthy process, or again, the repeat inspections that, if it passed once, why is it not passing anymore?
Was the question, what if you're not interested?
What if you're
Is it-
not interested in dealing with the lengthy Section 8 process and inspection?
Well, as far as, like I said, with the inspections, it's most of the time it's from what we've seen at least, it's an issue that is relatively easy to comply with. Like let's say, but I think maybe part of this question is getting at like, what if there's like a later inspection, like you pass the first one, there's a later inspection, and let's say the issue is caused by a tenant, or it's an issue that's assigned to the landlord, and the landlord just doesn't follow through on making the repairs, and as I described, it might eventually go into abatement, there might have to be an eviction, et cetera. Maybe part of that question is that source of income discrimination? At that point, it'd be very difficult to say that was source of income discrimination because you already accepted the person, you're, accepting payments, et cetera. I think just not complying with like a later inspection it would be hard to say that in itself would be source of income discrimination. I don't know if that's helpful, if that's answering that question.
Okay. This is, in general, what if an applicant wants to pay rent with Section 8 voucher, but the property has never been inspected or had other Section 8 tenants? It's inspected as per tenant. You have to have the tenant before you get an inspection, just so you know. It's inspected for each and every tenant.
Right.
I think what they're trying to get at on some of these is, a lot of times, we get cited for housekeeping issues.
Well,
Bad
that shouldn't, so like, let's say.
But we're
hypothet-
supposed to clean it up and
Right.
charge them for it, but
Yeah, and I should,
that doesn't work.
I should mention again, so like some of these questions are really good. They're starting to get into like the rules of the voucher program, a little bit different from like the issue of discrimination, in the application process. So I just want to be clear, like I can't really speak for the housing authority and how they
Okay.
do the HQS inspections. I can just say what I know of that process from working in this realm for a long time.
Okay.
you
An
go ahead.
applicant wants me to count food stamps as part of his or her income. Do I have to?
No, that's not income that would be used towards rent, no.
Pardon? Yes, I thought I already did. What if? Oh, here we go. Okay.
I think I missed the very first part of that question. I apologize.
If multiple potential tenants are putting in applications,
Mhm.
it feels like things have changed to where if you tell this person no, and everybody's even on the tenant, right, everything's equal,
Uh-huh.
they now have a leg to stand on to come back and get you in trouble for saying no, because they can immediately say, well, they said no to me because I had a voucher, and this person didn't.
I would just respond and say that, so the hypothetical so everyone's following is two applicants exactly identical, except that one's a voucher holder. So, and just like in any discrimination case, the burden of proof is on the plaintiff to show that, it becomes a question of intent. Like if the person, the housing provider denying the application, if their intent was, I'm not going to go with this person because they had the voucher, then yes, that would be source of income discrimination. But again, keep in mind that the plaintiff would need to be able to show that that was the intent. Does that make sense? Yep. Yeah, the penalties I don't have up on the screen, but in Toledo, it's a misdemeanor offense. And I apologize. I did not have a slide specifically dedicated to the penalties, but yeah, it's criminal offense in that
I'm happy
area.
to say
Yep.
most of us don't know what misdemeanor offense means. So could you explain what that means?
It's not a felony, it's it's a lower level of an offense, and there's a fee associated with it, and I apologize that I
Yeah.
don't have
That's
a
why I was
slide
wondering.
specifically
I
for
think that's
that,
what he's
but,
asking. What
yeah.
are the fees and
But-
penalties, or do we go to jail? Or
Yeah, right, yeah. And I believe it's an escalating, so if there's like multiple offenses, then, you know, it gets worse, et cetera. So.
is that when they throw in the testers to see if they can get multiple offenses?
I mean, that question is kind of complicated because to be clear, like the Fair Housing Center is not necessarily the entity that enforces this law. I just want to make sure that's clear. This is a City of Toledo law. So remember that very early slide, I said, these are the laws that apply within the City of Toledo, and these are laws that the City of Toledo has passed. So this is a law that is on the books for the City of Toledo, and it's enforced as a misdemeanor in our area. With that said, though, one thing to keep in mind is that since local law makes this illegal, and this issue does disparately harm minority applicants, it could create fair housing issues. And that's bolstered by the fact that local law makes it illegal. Hopefully that makes sense. All right, any other questions? Sorry, there's the one more question and then
Microphone.
I'll go on, yep.
Applicant for Section 8, for Fair Housing Voucher, and it takes a
This
month to get the inspector to come. In the interim, you have another qualified applicant. Is first come, first serve who has the money, right?
That's a really great question, and I'm surprised that I didn't get that one already. That's a great one. So, because that question it comes up sometimes. So her question was, okay, so what if that whole inspection process, you know, like you have to hold the unit for a while to accomplish that in order for that person to be able to get there? So the answer is you should be treating the applicants the same, right? So if you normally will hold a unit for some period of time to get that person some time to be able to whatever move in, or maybe you have like a holding fee that you charge. I know sometimes housing providers will charge some kind of application fee or to hold the unit for some period of time. You're still allowed to do those things and like keep a unit available for a certain amount of time. But at some point, yeah, let's say something goes wrong and it takes a really long time for the inspector to get out there.
Yep.
Then at some point, yes, it would, from a business purposes, it would be unreasonable, you know, at some point for you to just hold it indefinitely, worried about, you know, the person being, you know, ineffectively rejected. So you would just handle things the way that you normally would for other applicants.
In this day and age,
Okay.
is anybody taking holding fees?
I don't know. Those are. I think I've seen those very rarely, very, very, very rare. I didn't want to put that idea in anyone's mind, but
Okay.
they just come up sometimes. Okay, so water services. So just by way of context, I know that this seems to at least historically been an issue that has caused some amount of confusion from a policy perspective, not just in Toledo, but in a lot of areas. There's always questions about how to, if you want to have a single family house, let's say, and there's only 1 meter for it. Questions like, if a tenant moves in and the lease says you have to pay the water bill, are they responsible for the back bill, leading up to that point? What if there's just the charge is moving in is there? And then the questions about like, how do you deliver the bill over to the tenant? Are you doing that in a way that's like accurately, getting it to them on time? And is the information that you're providing to them about the water bill actually accurate? Et cetera. And also questions about like, once the person moves out, like how do you, account for like leftover charges? And then also questions about like, if there's assistance programs available for the owner, why can't like the tenant get access to it since the account is not in their name? Well, more recently, the city has started to recognize some of these problems with these issues, and then developed policies to account for those. One other basic policy question too is if you have like a multifamily property and there's only 1 meter at the property, water is obviously flowing to all the units, but there's not sub-meters. How do you figure out what the billing should be in that scenario? And I know that there's companies that claim that they can do RUBS or like these calculations that try to divide up the bill in some way, but that's its own can of worms, its own complications, et cetera. So let's talk about some of these policies that have been developed to try to deal with this. So first of all, one thing that I think this was that was at the end of 2020. The city of Toledo finally adopted a local rule that said that you can't just shut off the water by an order, like you can't call into the water department and order the water to be shut off at a property if it was occupied. In other words, as a way of like evicting the person from that property, you can't just like call to get the water shut off. The other cities have had policies like this on the books in Ohio that obviously like prevent this from happening. It's kind of a disaster scenario. If the person's like trying to live in the unit and they don't have access to water, they haven't been subject to any kind of eviction action with notices, et cetera, that's normally required. It tends to be a pretty tragic situation when that happens to folks. But believe it or not, if you weren't aware previously, the city of Toledo actually allowed the account holder to call and say, well, just shut off water at this property. I'm not there. I'm the account holder. I'm in charge of it. So just go ahead and terminate services, even if there was someone living there that hadn't yet been evicted. So the law changes that. If the city goes out and realizes, well, this is actually an occupied property, they might communicate back to say, no, I'm sorry, we can't shut this off. You're going to have to proceed with an eviction action, get the property, remove the people living there, and then at that point you can, terminate services if you'd like to do that. The other thing I should say is, of course, there's an exception for like emergencies or repairs, those kind of things. Obviously the water's allowed to be terminated for that reason. When the city adopted that rule change, they also changed, I know that's like a lot of text on your screen, but you may want to just read over, for your information, Toledo Municipal Code 933.07. But what this talks about is the process of the termination for non-payment. So the previous slide I was explaining was what if you did what's called an owner order termination, where you call the water department and affirmatively asked that services be shut off at a property. But this is if non-payment starts to accumulate on the account, what kind of notices would get sent out to the property where the tenant's at, what kind of options should the tenant have to be able to keep services on if the account's about to be shut off for non-payment. And these options are available to the tenant, even if the contract, the lease agreement that you have with the tenant, whatever that may say about how much is paid for water services or when it's paid or that they're responsible, if the account goes into delinquency and there's a non-payment, some of the just very basic options that the tenant has to keep the water services on is they can enter into, they're allowed to enter into like a repayment plan that would keep the account on whatever options that the account holder would have to keep the account on, the tenant has. So they can come in and like make a payment of some kind of themselves to keep the account on. Whether or not the tenant has recourse then against the landlord, let's say the lease says nothing about payments for water services, nothing about that at all, and the landlord is otherwise, apparently responsible for the water services because the account's in their name. But it turns out there's a delinquency and the tenant's worried that their water's about to be shut off, and they run in and just make a payment to keep water services on. Now the tenant may have some kind of recourse against the landlord to say, what's going on? You never said, that I was responsible for water, the account's in your name, I don't have access to the account, but I had to rush in and make a payment on this. You're gonna have to, reimburse me for that in some way. So this is some very basic rules, but it's also just making sure that the person at the property that's about to be terminated, where services are about to be terminated for non-payment, also gets like that notice of what those options are too. The other really significant change was the changes to water reselling. So as I said at the beginning of this part, there's often like confusion, and sometimes you would also really see just, to be honest, like sometimes really strange or arguably abusive practices where the person moves in saying, oh, your rent is one amount, and it just might say in there you're responsible for water bill. But then all of a sudden the landlord gives like these really big bills for water services, and the tenant doesn't understand it and wants to know more about what the charges are based on. Maybe the tenant's concerned that there's like a leak in the property, but how do they know if they don't have access to the account itself? This creates this kind of issue with the tenant not having the information they need about the account. So Toledo Municipal Code 933.06 set some just very, very basic rules for this. Landlords leasing single-family homes cannot charge the tenants for water services unless they provide the tenant with access to the account on a form provided by the Department of Public Utilities, and they cannot charge the tenant more than the actual bill for water services. So in other words, if you want to come in and say you're reselling the city of Toledo's water, you're going to say this person living at this property, even though I'm the owner of the property, I want them to pay the water bill. And you have a lease agreement that says that they're going to have to pay the water bill. Well, if you're going to do that, you have to give the tenant access to the account. That's basically what it says. And you can't try to charge the tenant more for that water services than what's the actual charges on the account. That's all that it basically does. And in fact, one of the forms that you got from Anna is that landlord-tenant agency form that gives the tenant that access to the account. If I were, a property manager, probably what I would do is just make that form that Anna handed out, that the agency form. If you want your tenant to directly pay for water services, just make that part of the lease agreement signing process. When they sit down to sign everything, just do the tenant agency form, so that if you're in a situation where you want them to be paying that bill, that's probably one of the forms that you would want to have them sign at the outset. Second part then, what about this? That was only for a single family. So you got one unit, one water meter. So it's clear like what the person's going to be charged, right? So what about multifamily though? So for multifamily, the law specifically says that you cannot charge the tenants for water services unless you do the sub-metering. So you got to give them the ability to know what their account is. And then you have to enter an agreement with the city of Toledo about that. So you have to notify the city and enter an agreement with them confirming that you're sub-metering, and those agreements would have some very basic rules about what's being charged, et cetera. This rule is actually not really that new. It just was very vague and kind of unclear in the previous version of the local municipal code. It did previously say that you couldn't resell water, and then the water department's administrative code gave a tiny bit more detail about the fact that they had these agreements that landlords could enter about the sub-metering if that were to occur. So that would sometimes be the case in manufactured home parks. That was an area where the city was trying to enforce these reselling rules, at least to some extent at that time. So you would have like manufactured home park where there's one main meter at the front and then like a series of sub-meters at each individual unit throughout the complex. And then the landlord, the manufactured park operator would track that in some way and make sure that people were actually getting accurate bills, and they would have an agreement with the city of Toledo about how that was functioning. But this rule the newer rule makes it very clear that for multifamily properties, you basically just can't do it unless you're willing to install sub-metering, which that in itself would be difficult. Make the business decision about whether you think that's worth it. But otherwise, it's better to just, whatever the cost of water is, it's better to just put that into what you're going to be charging for rent rather than try to pass that on to the tenant. So before I move on to this part, I think it might be helpful to just stop there on like the water stuff and ask if there's like any specific questions on that area, if that's okay with Anna and others.
We have one that says bills are running well over $2,000. What recourse do we have? if the leases say that the tenant's supposed to be paying it, but just like their rent, they're not paying it, and nobody's turning it off.
Yeah, so one thing a few things. From our experience of working in this realm, a lot of times if there's a bill that's that huge, I don't know why this is, but it's almost always a toilet leak. I don't know if, not always, but there's some things like obviously not, it could be broken or some kind of leak. So I would suggest starting with that to try to resolve whatever, that issue is.
No, we're talking about not being paid over COVID.
Oh, you mean, okay, so you mean for the period of time that there was like eviction moratoriums and things like
Yep.
that? Yeah, so you would still just have the normal recourse for any kind of non-payment if the scenario was, that you had a clear agreement, you were complying with all these other rules as I've described, and the bill was just very high, you would still be able to pursue remedies based on breach of whatever agreement you had with the person.
We have another one, I don't think it's got anything to do with water, but would a move-in fee be the same as a security deposit? Considered the same as a security deposit?
That's an interesting question. So, kind of not maybe exactly on point, but that's okay. So the security deposit, the thing you have to keep in mind about the security deposit is it's intended to secure performance in some way. So, like, let's say if it's just a quote-unquote fee for move-in, so maybe if that fee is intended to cover like cleaning and the cost of like considering that person's application and getting the unit set up, that's not securing future performance. That's accounting for a business cost that you have right now. So that would generally not be considered part of the security deposit. If, as a different example, you ask someone for a pet deposit fee that was intended to make sure secure performance about that pet, like make sure that pet doesn't damage the unit, then that should still be considered as part of the security deposit. And that could be really important for like accounting purposes, obviously at the end of the lease when there's a question about returning the deposit or what the amount of the deposit was. And also keep in mind that if the deposit is large enough, you're going to have to pay or account for interest on that. Sometimes landlords don't always realize that, but there's can be some interest accumulation if you're charging really, really huge amounts of deposit. So be aware of what's a deposit, what's a security deposit, and what is just a fee.
The way this is written, I believe it's if you're doing a move-in fee instead of a security deposit.
I think it just really just depends on what it's covering. Yeah.
Okay. Sending a water bill through a property management company requesting payment, is that not allowed anymore?
Oh,
You have a property management company?
so the scenario is like, let's say you have some whatever website or something where it lists like, charges and like one of them's rent, one of them's water. Did I get that right? Or?
Right through the portal, sending over the copy of their water bill.
Yep.
And they can pay right on the phone, or right through the portal, they see what the water bill is, they pay it.
Quick pay.
So let's say the hypothetical goes, it's a single family house, 1 meter, 1 unit. You had the person complete that agency form, like I talked about, so they have complete access to the account. That's what that agency form does. So if so the reason for that is if they wanted to know what the actual water usage was and what the actual bill was, they can contact the water department and get access to it and everything. That's great if that person was doing that, but yeah, they might have like questions to the water department, like contact them, and it also gets them access to those assistance programs, like the debt forgiveness program, and yep. No, it's just an agency, so it just gives them access only to the account for that address. They can't turn it on or off? No. Well, actually, I'm not sure about that. I don't think that they have the ability to do that. Yeah. Right. They wouldn't be able to turn it on in your name.
Yeah.
I don't think they would be able to turn it off. I'm pretty sure, I don't have the form in front of me, but I don't think, that's a good question. Right.
Actually, according to the form, it does say you get notifications of anything happening.
Right.
You still get the notification.
I mean, you're still also in charge of the account. It's just that person has access to the account too. Does that make sense?
Yeah.
Yeah.
In general, we've been asking the water company for decades, I've been on that committee, to do monthly bills because they're getting too big to expect people to pay. Well, their way of doing that is now they send out the bill monthly, but they still only read quarterly. All right, they kind of go halfway with you. It's the same thing we've been asking for 8 years to have the bill in the tenant's name, just like gas and electric. This is their version of it. They'll give them a copy of the bill to their house, but they're still not putting it in their name. So it's kind of like meeting in the middle, sort of. Right. It's
Right.
not in their name.
It's-
They're just
yeah,
getting a
that's
copy
right.
of the bill.
Basically, that's basically right, yeah. Any other water questions, or is that it? Yeah, yep. Yeah, the account is still, you have to own property to create an account for water services, and that is still it would be in your name, yep.
Of gas or electric in a landlord-tenant situation too,
Right.
where if they decide to turn it off in the middle of the winter and leave,
Yeah.
it automatically goes into your name and you get notified. So it's
Right.
sort of a version of that.
Yeah, it's an interesting area because different cities are different. Like the city is the water provider in our area. Well, like in Columbus, Ohio, for example, they're the city that's a municipal water provider, and they do it slightly different. Like tenants can actually can have establish the account. They create like these three-way accounts where all three of them have complete full control over the account. There's different ways that different cities. It's a little bit different, just as using Columbus as an example, but different cities do it differently just because they set the rules, locally for it. Yep.
If any families have them sub-metered, 0, right? That's what I thought.
Yeah, I think it would just be
run into
manufactured
any
home
yet.
parks.
Yeah,
Is probably
pretty
the main
much
place
mobile home parks.
Yeah.
All right. So remember, if you want to still keep charging water to your single families, you need to take that form we sent out,
Yep.
send it to them because it needs their signature too. You can do that like DocuSign, or if you've got a realtor friend, you can do it by .loop. I know a realtor friend. But so again, you can just send it out to them, and they're going to say, sure, I want a copy of the bill at the same time you get it. So they're going to hit that, send it back to you, and you've got it. I did a test. I sent out 6 of them, and I got 5 back already. So
Oh, cool.
just last night. So
Good. All right. Well, this last part, I have just like a series of roles that either are just noteworthy, just worth mentioning, or maybe issues that you're not necessarily aware of. So 1745.07 is part of the City of Toledo's housing code. And there's kind of 2 things in here that are noteworthy because they add to the existing rules under the State Landlord-Tenant Act. So under the State Landlord-Tenant Law, you have like these basic requirements of what is the landlord's responsibility, what's the tenant's responsibility. But part of what the state law says is that through local housing codes, these basic requirements could be added to in some way. So one, and I know again this is like a lot of text on the screen, but the state law says that if there's 4 or more dwelling units, then the landlord has to be responsible for garbage collection. So like that main dumpster in the back. But the local housing code says 2 or more dwelling units. So it's like a local additional requirement that a lot of folks might not be aware of in the area. The second one that's, I think, it may be noteworthy, folks may not be aware of is, and by the way, these have been on the books. These are actually not new. This has just been in the part of the housing code for I don't know how long probably before my time. So they're not one of the kind of newer rules that Anna had mentioned previously. The other one is infestation of insects or rodents and things like that. So if there's 2 or more dwelling units and there's an infestation, the owner is responsible whenever such infestation exists in 2 or more dwelling units or in the shared common parts of any dwelling unit. So what that means is, so let's say you've got like a multifamily complex and you find out that it's not just one place. You might think, oh, well, this is really just this one tenant because it's like a, a cleanliness issue. But actually, it turns out it's in like just the common areas and in multiple units. The local housing code is specifically indicating that the owner is responsible at that point, if it's like in multiple units and if it's in the common areas of a multifamily complex. I mentioned that just because we sometimes come across, I mentioned both of those, sometimes we just come across situations where the landlords just aren't always necessarily aware of those rules, and tenants as well aren't necessarily aware of those additional provisions in our local housing code. Another one that a lot of folks are not aware of, and this again is not a new one, this has been in place since the foreclosure crisis. It was passed not long, I think it was in, I want to say 2009 or so. It was like well into the foreclosure crisis, where we just saw like tons and tons of turnover. And at that time, there was a lot of tenants and as well as property owners too, just complaining about the ability to communicate with the tenant and the tenant's ability to know who the owner was. And a lot of tenants had at that time, my understanding was that they had approached city council and said, look, a lot of times the ownership changes after a foreclosure and we don't know who the new owner is, and we're worried about like where to pay rent and things like that. So the basic idea of this law is if there's a foreclosure, if the property transfers as a result of a foreclosure, then the tenant has some very basic rights to notice. And so if you're a landlord who's currently in foreclosure, then there's some requirements to notify the tenant that there's a foreclosure action occurring. And then after the property is sold, the new owner is required to notify the tenant once they've established ownership, once they've taken control of the property or become the title owner, I should say. There are some penalties in place for this. I don't know that a lot of people are aware of this rule, but perhaps another thing to be aware of too is that the tenants, if there's non-compliance with this, the tenant has the right to terminate the lease with a 30-day written notice to the landlord. So even if they were locked into a longer-term written lease, and there's this foreclosure process is occurring, and it gets to a point where it triggers that notice requirement that I was describing, the tenant would have this ability to say, well, I'm really worried about what's going to happen with the property, so I'm going to go ahead and give this 30-day notice that would allow me to terminate the lease early. Again, it's just another one of these local technical rules that a lot of folks are not necessarily aware of, both landlords and tenants, so it's worth pointing these out. And the last, I'm just going to really actually kind of briefly mention these last two. That's the pay to stay and the right to counsel rules. Those were also part of the list that Anna had distributed and that she also specifically mentioned. These are, as compared to the last two slides, which are a little bit technical, these are actually much easier to understand. These specific, like the pay to stay, it basically just says that the tenant has an affirmative defense to an eviction if they offer to pay all the rent and late fees that they owed, in order to stop an eviction for non-payment. So the scenario is that there's potentially an eviction for non-payment. They get the 3-day notice, let's say, but then the tenant offers to pay everything they owe along with the late fees, reasonable late fees. If they do that, then it's the defense to the eviction action. So, let's say if the landlord says, you know what, I don't care, I don't want the rent and late fees, all the rent that you owe and all the late fees that you owe, I'm still just going to evict you anyway. This would create a defense in that situation. And that's true all the way up to the judgment for eviction. So even if you got to court, even at any point prior to the eviction judgment, if that tenant offers all the rent and all the late fees that are due, then that would be an affirmative defense to the eviction. Now, this does not cover other reasons for eviction, like if they, were failing to maintain do things, they were creating maintenance issues at the property and some violation of the lease, if they were punching holes in the wall or whatever the case may be. This has nothing to do with that. It's just about non-payment of rent, and it's only a defense if that person offers to pay the full amount that they owed along with the late fees. And then second, so the quote-unquote right to counsel bill.
George?
Yep, go
George,
ahead.
sorry, could I just also add that pay to stay includes a cap on late fees? And I don't know offhand what those are, but I'm trying to look those up.
Yeah, it does. It's worth mentioning those. But that rule, by the way, is kind of always been there. The late fees
Actually,
should be reasonable, but it does set like a more specific requirement for those. Then the second thing is
can I also
Yep, go
ask,
ahead.
is that, you said offer to pay? Is it,
Yeah.
you have to accept,
you have to
Well,
they have to tender the payment.
they
Yep.
have to tender
Yeah,
the payment?
so,
I
yep.
just want to make
Alright.
sure.
Yeah.
And there was also one question before on the prior one as far as the foreclosure. You said the
Yep.
tenant could give 30-day notice to move if they wish, but you didn't say how much notice the owner had to give
Yeah,
regarding,
sorry.
is that a 30-day also?
No, so if the tenant's notification, the change in ownership, for example, is that within 7 days after the ownership changes, after the foreclosure sale, or
days
if the tenant, has if moves in with there's a pending foreclosure action, then they have to give notice of that pending foreclosure action within 7 days after they've moved in. And if the pending foreclosure action gives that tenant the option to offer that 30-day notice. And so those notice timing requirements, if you want to look specifically at that chapter, it's at 1769, depending on what point you're at in the transaction. If you're someone who just bought it within 7 days after purchasing the property at the foreclosure sale, for example, once you take title of the property, that would be when that notice requirement for the landlord triggers.
And there was one other back question too on the pest. If their leases normally say, for the first 30 days of pest or sewer or anything like that, the landlord pays it, and after that, if there's been no problems, the tenant then assumes payment or correction of either sewers or pests. Is that legal?
I'm not sure if I quite followed that question. Was that about the
The pests?
who's responsible if
Who's
the pests are in
yeah.
multiple units?
No, just,
I'm sorry.
it didn't say, so I guess it could be single family or multiple. So the
Okay.
pest thing is just for multi-units?
What I was highlighting here was the point that sometimes locally, like sometimes landlords, there's a confusion about if there's a rodent or a pest infestation. There's sometimes a question like, well, who's responsible for that? Was that a housekeeping issue, or was it like a maintenance issue that that the landlord should be responsible for? Sometimes that's a dispute between the landlord and the tenant. What this local law does, though, is it says, well, if that issue is in multiple units or in the common areas, it decides that through that local law. It says, well, look, if it's throughout the multifamily complex, then it's the owner's responsibility. It's not, you can't try to,
Okay, so it doesn't even
resolve
cover
that.
single family?
This particular provision
Okay.
that I thought would be noteworthy because it adds something to the state law, no, it does not specifically
Okay.
deal with
All right.
single family. Yep.
That's clear.
I found the cap on late fees.
Okay.
It's may not exceed the larger of $25 or 5% of the monthly contract rent.
Is that per month or is that like for the whole year contract or for a monthly contract?
Sure.
Yeah.
Okay, I'll read this section. Reasonable late fees. No landlord may charge a tenant late fees that are not reasonable late fees. If a rental agreement includes a provision that authorizes the landlord to assess the tenant a fee for late payment of the monthly rent to be considered reasonable late fees, the total amount of that late payment fee, total amount, for any month may not exceed the larger of $25 or 5% of the monthly contract rent.
That's per month.
So
Okay.
the total amount per month cannot exceed the larger of $25 or 5% of the rent.
Okay. And then the second part of this was the right to counsel. So I think from just to be clear, what this does is it doesn't really necessarily create a quote unquote right to every tenant to have legal counsel in court. I mean, I know the name of it may imply that, but that's not what it does. Really what this local law does is it just, in bottom line, is it increases funding. It provides some funding to the local legal aid organizations so that they can increase the number of eviction cases that they have the capacity to handle. But it doesn't, just because this law was passed, you would not necessarily expect to see like a legal aid attorney on every single, eviction case and representing every tenant. It does not do that. It's only intended for low-income tenants, and it's only to the extent that the legal aid organization locally has enough funding, to cover that. And the city of Toledo sends them some additional funding for that purpose. So that's basically what that rule does. I am not here going to get into the lead ordinance. There's just way too much content or potential discussion there. I would just, if you're not already aware of it, this website is very, very, very helpful. That's ToledoLeadSafe.com. It has a lot of information, contact information, and resources, et cetera, if you weren't already aware of that. And I know this is something that Anna and others have mentioned before at these meetings, but that's a great resource since we don't have time here to discuss that. Finally, this is the last little section that I wanted to mention. For this again is actually not a new rule. It's just a rule that's been on the books for a while that a lot of folks are not aware of. So the city of Toledo has something called a certificate of property code compliance, and that's actually a part of a copy of the actual certificate. This comes into play like if you are transferring a property through a land installment contract. The local code says that you need to have this certificate of property code compliance before you transfer the property pursuant to a land contract. And you can contact the Division of Building Inspection to schedule that inspection that needs to occur before the land installment contract sale occurs. The second way this same form comes up is if you have a rental unit and at some point it was subject to an order from code enforcement or from the health department. Let's say like you have a porch that started to cave in or something, and you got an order that forced you to reconstruct it. If there was ever some kind of order like that from code enforcement or health department, then before renting it out again, the local code says you need to have this like certificate of property code compliance before you're able to rent out the property again at that point, to obtain that code, to get that inspection scheduled and have that conducted before you rent it out. Again, another requirement that a lot of folks are not necessarily aware of, but has been on the books for a few years. I will turn to Q&A. Well, actually, before I do this last slide, which I just want to circle back to our landlord-tenant mediation program. But before I do that, I'll just back up and see if there's any other questions about those last few slides. I know some of that information was like a little bit technical, so I'm happy to try to entertain a few questions if there was something on one of those previous provisions. If not, it's okay.
For ownership transfers for foreclosure, there's often no tenant information for at least 30 days. Do
Right.
we physically tape notices to the door like we do
It-
for eviction courts, informing tenants of
right.
change of ownership? And what happens when the tenants deny receiving the notice and don't pay? That's
Okay,
it.
well, a couple of things there. First, the law does not specify the way that the notice has to be provided.
Okay.
So you could just go out there and, like, let's say, put it on the door, or, provide to the person who's there. And then second, this doesn't interfere with ability to collect rent, to be clear. It's just about this notice. You have to provide the notice, and potentially there's this risk of some potential penalties, and there's a risk that the tenant could say, I don't know what's going on with this foreclosure case, so I'm just going to, under this law, I'm going to provide a 30-day notice to terminate my lease and be able to move. That's part of what the local law says. So.
Okay, and a clarification, the land contract changes hands. Land contract changes hands at the end of the land contract, not the beginning.
Oh, that's true. I meant the vendor-vendee relationship, like before you execute that agreement I'm not talking about the final transfer at that end. I mean, when you go to execute the land contract, transaction, before the person signs on, you need to have that certificate of property code compliance, not at the end of it when you're,
I guess we need, as
taking
realtors,
ownership.
then we need a copy
Yeah.
of that, because there's a
The-
big difference between the two.
I'm sorry?
Between it changing hands actually on the deed.
Right, and as you know, the real estate isn't ultimately the title isn't transferred until the end with the land contract, yep.
Right.
Okay. All right. Well, then finally, I know that was a lot of information. You don't feel overwhelmed by that, because the reality is a lot of these issues can be worked out with the two sides just talking to each other, landlords and tenants working these things out. And part of one of the programs that we provide is our landlord-tenant mediation program. And it's available for both landlords and tenants. Now we do get more calls from tenants saying I have this question or issue with my landlord. Can you try to help me out with it? So basically, what the program does is it provides some education and information to both sides, and it also assigns a professional mediator to cases. The mediation is completely voluntary, so it's up to both sides if they want to participate. But the mediator, a lot of times what they do is shuttle mediation, so they'll call both sides and say, is there some way we can work this out? And maybe in that process, they're providing a little bit more information, education to both sides, and finding some kind of solution to whatever the issue is. That's the intent of the program, and it's completely free to both landlords and tenants. I will say that the tenant does need to be able to complete some forms to confirm their income. So it's primarily for low to moderate income families. We do ask that the tenants complete information so that we can verify for our grant purposes, but we don't really deny. We certainly definitely want to get the calls from landlords. So if there's any question you're not sure if they would fall within the income guidelines, just call anyway, and we do still serve folks even if they're a lot of times even if they're up at the higher income, because of this program is trying to reach everyone and build those relationships with
So
landlords.
the tenant or the landlord has to meet the requirement of income?
This is just the tenant. The landlord does
tenant.
not have to complete any kind of forms. No, it's just the tenant that we ask for a little bit of information from if they're interested. in
Might I give
participating.
accolades that I have used it twice, and both times it's been very excellent, because quite often it's one side or the other doesn't really understand the system, and coming from somebody else makes all the difference in the world, because they tend to want to believe what they want to believe, whichever side it is, and then when they hear what it really is, sometimes that just takes care of the situation right away.
Yeah, a lot of these issues, you don't even necessarily have to get into too deep into the law. Like this part of this
Right.
presentation was just giving you some additional details, so hopefully that's helpful on these local provisions. But A lot of these issues can, like I said, be worked out with some phone calls back and forth and some mediation services.
I don't know if you mentioned, I don't think that you did, that you do have to be a resident of Lucas County for this particular program.
Yeah, I'm sorry.
That's the only
Yep,
requirement.
that's the only other requirement is Lucas County. Yep.
And you only have to be a resident of Toledo or your houses in Toledo to go through all the rest of these laws.
Yeah, I'm sorry. The tenant has to be a resident of Lucas County, I should say too.
Yeah.
And then to answer your question, all those local laws I just listed, those are only for if you're rental properties in the city of Toledo.
Yep.
Yep.
Most of the calls I get as a realtor is, what do you have not in the 436 zip code? So it's unfortunate. We hope to change that.
All right, and my email information is there as well. If you'd like to email me, I can try to answer questions. Actually, I'm sorry, our address is wrong on there. We're actually at 326 North Erie Street. We're still relatively new at our new location. It's where the old Chicago Title Building was. So ignore the address, but the email is correct. So, and then you can also feel free to call us at the number, the 419-243-6163 number. And I think that's it, unless there's any other questions. This one?
I think everything that I did with mediation was pretty much all over the phone, too. It was,
Most
Very
of them are,
convenient,
most of the mediation cases are kind of a shuttle mediations where there's phone
Yeah.
calls back and forth. We do have a conference room and the ability to schedule in-person mediations or Zoom
Yeah.
mediations too, if that's helpful though.
and they have the ability, we emailed some pictures back and forth, and everybody was happy.
Okay.
And in addition to the materials that we left on your chairs, there's also extra materials by the table when you leave, so feel free to take anything that you'd like. But thank you
That's
again
for
so
these
much
guys.
for having us. I really
Yay.
appreciate it.
Good job.